Hi, welcome to the 43rd session on IBC, specifically dealing with liquidation. Let's recap what we have done in session 42. In the session 42, we have discussed on the circumstances which lead to initiation of liquidation. After that, in section 34, we have seen how to appoint and replace the liquidator. On section 35, we have seen powers and duties of liquidator along with certain case laws. I hope you're very clear, and I'm sure you are revising from time to time. So let's go forward. In today's session, it's a slightly longer session. We will have more syllabus to cover in this. So we'll be quick in our coverage today. Once you understand this, you know how liquidation will generally happen and what kind of liquidation estate will constitute for sale proceeds. Liquidation or liquidator creates a liquidation estate for the CD's assets. That's the first thing. Liquidator holds the estate. Now that liquidator has created an estate, an asset base, this asset base is in the hands of liquidator, but he does not have any title to them. He will not enjoy benefits of that estate, but he will only be acting as a trustee for the benefit of creditors. In other words, we call it as a fiduciary capacity in which he is holding these assets, and hence he is ultimately accountable to the creditors for sale proceeds. The last line, there are certain inclusions and exclusions for the liquidation estate. We're going to shortly see what are inclusions and what are exclusions. Without wasting time, let's go to next slide. And what are these? These are nothing but the inclusions into the liquidation estate. That means the following type of assets can be part of the liquidation estate, positively mentioned in section 36. So what kind of assets can be part of the liquidation estate on which ultimately the creditors will have beneficial interest? Number one, assets on which debtor have ownership rights. That means a certain plant machinery whose owner is a corporate debtor, that is certainly part of the liquidation estate. I'm not going into depth with that. It is pretty easy to understand. Ownership rights. Two, intangible assets such as copyrights, patents, trademarks, designs, etc., which are not tangible assets, can also be part of liquidation estate. Just for an example, if you know Chota Bheem as a brand, right? But Chota Bheem actually, apart from doing animations, does not produce a lot of articles and goods. But you can see Chota Bheem's characteristic being put on hundreds of things and goods. That Chota Bheem character being trademarked will result in crores of revenue to the company which owns those rights. So these, IPRs or not something that are very cheap. Depending on what kind of intellectual property you've created, intangible assets can yield you phenomenal sale proceeds at times. Therefore, those are important part of your liquidation estate. Any relinquished security interest which you have thought that I don't want it for now. Assets in possession, including encumbered assets. Any assets that are in possession of the company under liquidation can also be called as part of the liquidation estate, including also encumbered assets. Then assets under dispute can also be part of a liquidation estate, but however, the sale proceeds will become part of the liquidation estate only subject to the dispute being resolved. Then any property vested in CD at the beginning of the CIRP will also be part of the liquidation estate. Tangible assets such as movable, immobile properties, assets or value recovered through avoidance proceedings. This is an important part of the entire liquidation. Please remember, we call it as avoidance proceedings. Mark that, write it somewhere. And eventually when we are talking about the entire liquidation process, I'll make it very clear to you what kind of asset that is. So currently we are trying to understand that in case you have taken proceedings against any party under avoidance transactions, then if you have recovered any money from such proceedings, that will become a part of liquidation estate. And lastly, proceeds of liquidation will become part of the liquidation estate. All this should be paid to the creditors. This is important. Then obviously the next question is, what are the exclusions which cannot form part of the liquidation estate? These are the exclusions. First one, obviously logically, assets owned by third party, though they are in possession of the CD, cannot actually be part of the liquidation estate. Those should be returned to the third parties. Workmen's dues like provident fund which is accumulated, which is not paid to the employees, if it is there lying in your bank accounts, cannot be treated as an asset of the company. It has to ultimately go to workmen and employee, hence that will not form part of the liquidation estate. Please mark these words. Then assets in security collateral cannot also be part of the liquidation estate. Like let's say you borrowed a certain loan from a certain bank and you have given a certain property as collateral to that bank, and there's a default in repayment, that bank will actually have the first right on such security and collateral, and hence that cannot be part of the liquidation estate. Then if you look at the second row, first it talks about assets held in trust for a third party. Third party has given you certain assets and said that please hold these assets for me. Those assets cannot be part of the liquidation estate. Non-transferable contractual assets which you are holding cannot be, like a hired machinery which is with you. That has to be returned one day. These are not transferable to you, and hence those are not part of the liquidation estate. Personal assets of the shareholders which have been given to the company for a temporary use, also by the partners for temporary use, cannot be called as liquidation estate. Bailment contracts where the goods are held for a temporary moment and after that they will be returned. It can be any property. Then the next one, if you look at third row, second column, we are talking about other assets as notified by the central government may not be part of the liquidation asset. Then assets belonging to the subsidiaries of the CD. Though holding company will have shares in the subsidiary company, but the assets of the subsidiary company belong to subsidiaries. The holding company will not have any right on any particular asset of a subsidiary company, and hence it is not part of the liquidation estate. I'm sure now with the help of these two slides we are clear as to what are inclusions that can go into liquidation estate, what are exclusions that cannot go into liquidation estate. This is all about section 36. Now let's look at a case law that brings a lot more clarity as to how do we understand section 36. This is BR Traders versus Venkatramana Rao, Nagarajan and others. This is dealing with section 36 of the Act, and the adjudicatory authority is NCLAT, not NCLT. Therefore, remember it's an appeal at the appellate tribunal. Facts of the case. The appellant claimed, whoever was making that case, claimed that the machinery belonged to it rather than the corporate debtor, while clause 15 of the internal agreement entered between them. So, somebody has given some machinery to the CD under an agreement in which clause 15 says perhaps that the machinery belongs to the third party and not to the company. So the appellant is claiming rights on that machinery under agreement. Fact number 2. The resolution professional with reference to section 36 of the IBC denied the fact that there is any such agreement or any such right. He says that there are several claims and counterclaims between the parties, hence it is not clear who owns what, and hence he wants it to bring it to the liquidation estate under section 36 of the Act. Now I'm sure you are understanding what is the issue. Issue is to decide who will be the rightful owner of the property and should it go to liquidation estate or not. Now let's see what has come. This is the issue, as I said. Number 1. Terms and conditions of the agreement, will they prevail over the IBC, which has an overriding effect, IBC or the agreement? 2. The appellant argued that the asset to be handed over to them and the same shall not form part of liquidation estate. So now NCLT shall determine conclusively as to who should be the rightful owner of these assets. Analysis, we are saying again and again, we have to look at various Supreme Court and NCLT decided cases to understand that IBC will have an overriding effect on all agreements between the parties. Right? Whenever there is a conflict between IBC, its provisions, and private contracts between the parties, IBC is definitely having an upper hand which has an overriding effect. That's analysis number one. Analysis number two, the apex tribunal held that the appellant shall only be able to recover its claim as part of the resolution plan, or if the same is not approved, then as a claimant in the liquidation estate. If you think that you have rights on property, you can claim your money under resolution plan, or you can claim under liquidation plan, but you cannot insist on the assets be returned to you. Let's look at conclusion here. Conclusion: NCLT held that machinery forms part of the estate of the corporate debtor and the appeal was dismissed, hence liquidator will win and this asset will go to his estate. NCLT held that the act of the resolution professional was absolutely correct and directed accordingly to continue with the liquidation proceedings. So now we are clear about what is section 36 saying. There is also one more case that makes it very clear as to what cannot be part of liquidation estate. This is section 36 of the Act, Precision Fasteners Limited versus Employees Provident Fund Organization. NCLT Mumbai bench is dealing with that matter or dealt, and issues involved are: number one, whether or not the provident fund and pension fund, which is due and payable to the workers but not paid yet, will it be part of the liquidation estate of the CD or not? Without I going forward showing you the result, I want you to just quickly stimulate your brain. Think, what is that we have read under section 36 in the inclusions? What is that we have read under section 36 under the head exclusions? And do you think provident fund and pension fund will be inclusion or exclusion? Quickly. I'm sure you got the answer, but anyway, let me go forward and tell you what is the conclusion. Conclusion is NCLT held that in light of the section 36 of the code, the dues in respect to provident fund and pension fund and gratuity fund are not part of the liquidation estate. Very loud and clear verdict that there is no dispute in future cases as far as PF, gratuity and any other employee benefit is concerned. Now we move on to section 37, which talks about powers of liquidator to access information. There is nothing much in this to really understand, complicate or analyze. Let's quickly read out what are the provisions of the section and what it says as to how do you get your information. Only one thing that you must note about this section: as a liquidator, unless you have information on what assets do you have and who owes you money, you cannot actually make a great liquidation plan. Hence, section 37 gives a specific power to liquidator to get information, and he will have access to information, which are the following sources, right? So let's look at sources for access. Number one, whenever in doubt about information, he can have a full access to the information utility to understand what are the debts, borrowings of the company and what kind of assets are available. Then credit information system maintained by various agencies across. CIBIL rating is what we call. That will affect your credibility, right? So credit information system is what we call in broad, and the liquidator shall have access to credit information systems to understand what is the information available. He will also have an access to government agencies, financial, non-financial liability systems, securities, assets information, database maintained by IBBI, and various other sources. So whenever in the capacity of a liquidator, if I ask for information from any of these listed sources, they cannot deny information. They shall provide timely information to me. Also, Section 37 says, the second part of Section 37 says that the right to information is not only of the liquidator. Even the creditors have a right to information. Therefore, they can also seek information or ask information from the liquidator, and in which case there are primarily two responsibilities or obligations on the liquidator. Number one, he shall provide the requested information within 7 days from the date of request. And if he cannot provide the requested information, then he must provide a reason as to why he is not able to give the information to the creditor. So 37 is simple. Liquidator has a right to information, so he can access various government agencies and also utility centers to get information. Number two, creditors have an right to access, therefore they can ask the liquidator about the information, and liquidator is bound to give them information. Let's move forward. Now we go to section 38. This talks about consolidation of claims. What do you mean by that? Claims are two types. Number one, I can claim in the capacity of a financial creditor. Number two, I can claim in the capacity of an operational creditor. How should I claim if I'm a financial creditor? How should I claim if I'm an operational creditor? And if I'm both, sometimes it is possible that a certain agency can be a financial creditor, also be an operational creditor. Then how should I claim? All those are written clearly on this slide. Let's go forward to understand. First line, the liquidator must receive or collect creditors' claims within 30 days from the commencement of liquidation. Therefore, he makes an advertisement and asks for everybody to make a claim to the liquidation estate, and within 30 days people should make a claim. Now, if you are a financial creditor, how do you submit your claim? Very simple. You must give a record of the claim, which will act as an evidence. If an information utility maintains a record and puts your name as a creditor with a certain sum of money, this is enough evidence to say that you are a creditor and you can make your claim. Part 1. How do you make your claim? I said already, with the help of the record. But if the claim is not recorded in any information utilities books, then you must submit a specified form plus also supporting documents which can be substantial evidence for your credit to the corporate debtor. This is part 1, which is a financial creditor. On the other hand, if I am an operational creditor, remember in the case of an operational creditor, there will not be a recorded evidence in the information utility. Therefore, operational creditors shall always submit a specific form plus the supporting documents to establish his credit from the corporate debtor. But in case a creditor has both, then he must make two different claims in two different ways that we have discussed till now. And last and the most important point is, a claim can be withdrawn if you feel that it is not viable, or you can modify the claim if you feel that you have under or overclaimed your money from the corporate debtor. Let's move on to section 39. Section 39 talks about verification of claims. What do you mean by verification? If you are asking everybody to claim what they want from the liquidator, everybody in the world can make a claim and say that, the CD owes me money. As a liquidator, it is my primary responsibility to see whether the claimant is stating truth or not, and whether his claim is correct or not. This entire process is called as verification of claims. The liquidator must verify the claims submitted under section 38 within the time period specified by the board. We are going to see the time period eventually, but let's try to understand the section. How does he verify? He will look at the supporting documents. He will look at the record produced by the financial creditor and determine whether this claim is genuine or not. And if it is a original genuine claim, then he is going to admit that. The liquidator may ask any creditor or the corporate debtor for any additional document or information if he is not convinced that the claim is complete. Therefore, he can ask more and more information until he is convinced, and once he is convinced, now he will take a decision. This is section 39 of the Act. We've seen that basically there are claims, verification of the claims, and after the claims are verified, of course, you will now have to decide whether you are going to accept that claim or reject that claim under section 40. After verifying claims, the liquidator may admit or reject a claim either in whole or in part. Always remember, if an excess claim is made by the creditor, the liquidator may accept what is a reasonable claim and he will reject only that claim which is over and above the acceptable limit. In that case, it is going to be a partial acceptance. In some cases, he may totally reject the entire claim amount. This section gives a phenomenal flexibility where the liquidator may partly accept your claim and partly reject your claim, or he may wholly accept or wholly reject your claim. But if the claim is rejected, the liquidator shall give his reasons in writing. The liquidator must communicate the decision of admission or rejection within 7 days of making the decision to every claimant. In the case of Prasad Gempex versus Star Agro Marine Exports Private Limited, Section 40 of the Act has been dealt with by NCLAT New Delhi. Watch it, it is not NCLT, it is NCLAT, therefore it is going to be an appeal at the appellate tribunal. Issues involved: whether a creditor can file a claim after failing of the resolution plan. Point is simple. I would have made a claim and resolution plan failed, or I wouldn't have made a claim. It doesn't matter. Now when it comes to liquidation, can I make a fresh claim again? Is a question. So what is the answer? NCLAT decided that in case the resolution plan is not approved and the order of liquidation is passed, in such case it will be always open to the parties to file a fresh claim before the liquidator under section 40 of the Act. Therefore, failing of a resolution plan or failing of a CIRP does not in any way affect the rights of the claimants, and therefore they can actually make a fresh claim when it comes to liquidation as it is. So, we have come to the end of session 43, in which we have understood 5 different sections, starting with the liquidation estate. What are inclusions? What are exclusions? Powers of liquidator to access information. How the claims are made by the financial creditor, operational creditor, and a person who is both. And finally, how does a liquidator verify the claims and what decision he can take, and if he has taken a decision of acceptance or rejection of a claim, within what time he should communicate. Remember, 30 days is the time for making the claim, and once the decision is taken by the liquidator, he shall inform all concerned within 7 days of his decision. So this brings us to the end of the session 43, my friends. We will meet in session 44.